Good morning, everybody. Today is Wednesday, June 29th, 2022. We are here for the Marion County Board of Commissioners Board Session. It's 9 a.m. in the Senator Hearing Room at 555 Court Street, northeast of Salem. And if you would, please stand and join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I don't know if everybody noticed, but we have a huge agenda today. And we have several people signed up for public comment. So we're going to keep the comments today at 2 minutes, and Commissioner Cameron is going to time that. And the public comment individuals are going to come over to this microphone to speak to the board. And the first individual signed up is Toby Green. Hi, Toby.
Hey.
Would you please introduce yourself, your residence, and the purpose of your testimony today?
Sure. My name is Toby Green, and 1730 Commercial Street here in Salem, Oregon. And the purpose of my testimony is there's a telecommuting policy that's going to go into impact, and I just wanted to bring some information for the Board of Commissioners for you folks to review and take into account.
Great, thanks.
Okay. My name is Toby Green. I am the SEIU organizer for MCEA. Before I start my little presentation, I do want to thank the Board of Commissioners for your cooperation during our recent bargaining session. We had a really productive session and wanted to thank you for your support of the Marion County employees. I also wanted to say that the purpose here is that we have a teleworking policy that is going to go into impact on July 1st that we just wanted to raise because we are hearing a significant amount of chatter from our members, from our workers. We did a survey recently in which 94% of the members of MCEA support a teleworking policy. We know that it is under review and being looked at, but we wanted to express the urgency towards this policy. We know that the way of the future and the way things have been going since the pandemic, we're in a new type of normal, and having a teleworking policy increases the desirability of folks to come to work and stay at Marion County. The back to work policy that was recently announced is bringing people back to work at Marion County, force them to work from the office. We heard quite a bit of chatter. During bargaining, it was made clear to us that this was going to be a policy. If anything was going to be done, it was going to be done at the Board of Commissioners. That's why we're coming here to share this information. I do have some placards I'm going to be leaving here, which has comments and testimony from members who could not make it here today to be able to testify. And Shauna will leave it there. You folks, it's a business decision. It's a county business decision. Our goal here, and you might hear some testimony here today from this piece, is just to make sure that as you make this decision that you're hearing this type of input. So I want to thank you for your time.
Thanks, Toby.
Thanks.
Have a good day. Next is going to be, it looks like we have some arrow changes. Trish Straw. Okay, is she not here? Because she's signed up.
She is, I will go get her.
Okay, well, we're going to move on to, is it, I don't know if it's Brian or Brianne?
Brian.
Smith? Brian? Great. Sorry. I think your N is connected to your S.
Good
For the
morning.
record, introduce yourself, your residence, and your purpose of testimony.
I am Brian Smith, and my address is 930 Barnes Avenue Southeast here in Salem.
Thank you.
And I just wanted to give some testimony about telecommuting and how I support that. Ready?
Thank you.
Okay. So the type of work I do here at Marion County isn't work that can necessarily be done through telecommuting, but I still believe telecommuting is a very important and useful tool. I've heard from many coworkers about how telecommuting helps them feel more grounded. They're able to achieve their work, and it provides for a nice work-life balance and helps lessen the unnecessary stress of everyday life. Furthermore, through my interactions with my coworkers who telecommute, they've also stated to me that they feel more productive while telecommuting, that they have been able to help the community in wonderful ways while telecommuting. So please, take action quickly to develop and implement a Marion County telecommuting policy because happy, healthy staff who are highly productive is a win-win situation for the residents of Marion County. Thank you.
Thanks, Brian. Nice to see you. Have a good day. Okay. Is Trish in here now?
Yeah.
Great. If you please come over here, you're signed up to provide testimony. And you missed the introduction. You have 2 minutes.
Okay.
And for the
Sorry
record,
about that. I thought we were going to start at 9:30.
oh no, our public hearing is at 9:30.
Okay.
For the record, please give us your name, your residence, and your purpose of testimony.
My name is Trish Straw, Marion County. And what
Your
is-
residence and your purpose of testimony, like your address.
I work for the county. I'm not going to give my personal address.
Okay? Which
Yeah.
purpose of testimony?
All right. So thank you for waiting on me. My name is Trish Straw. I'm a Marion County employee for the Health and Human Services Department, and I'm also the elected president of Marion County Employees Association. I'd like to start by saying thank you for coming to an agreement on our bargaining contract. However, I really did not want to be here today, but you left me no choice. You have refused several times to meet with union representatives or listen to our members' concerns surrounding the county's decision to end the telecommuting option. You refused to bargain over it. You took it out of HR's hands and declared sole responsibility for looking at a telecommuting and/or hybrid countywide policy. I was elected president of Marion County Employees Association, which represents nearly 1,000 of your employees, to speak on their behalf, just as you've been elected to represent the people of Marion County. You have stated you have an open door policy, which as elected officials and also our bosses, you should. So does that open door extend to employees that are part of a union and those employees elected as leaders of their union to speak on their behalf? It doesn't appear so, as I'm here this morning, because you have yet again refused to meet with your employees and their union. Since you refused to bargain over telecommuting and instructed us to follow up with you, we're here today to support our members that would like to speak on the matter. We wish to share this information with you in the hopes that you reconsider your position. However, we are not interested in making the county's decision. We're interested that you have all the data needed to make a good decision. And with that said, whoever is next, I'll go ahead and step back.
Thanks,
Thank you.
Trish. Have a good day. Next is Diana Downs.
Good morning.
Good morning.
My name is Diana Downs. I live on Meadow Lawn Loop here in Salem. I work in the assessor's office. I am MCEA officer, steward, and a member of the bargaining team. At the time the union and the county came to agreement over the terms of the contract, somewhere around midnight on that day, I was happy and excited and really, really tired. It felt like the county had finally heard our concerns and had responded. Perhaps this was the beginning of a new chapter and a collaborative effort between the employees and management of Marion County, and for that I would sincerely like to thank you. However, today I find myself with conflicting emotions. I am grateful for our contract. However, I'm saddened that the most important issue to employees outside of economic issues appears to not be given the attention it deserves. As I said, I work in the assessor's office. We're responsible for generating a good portion of the revenue for Marion County and the districts within the county that it serves. I will easily admit that I feel like I have a personal stake in how Marion County spends its money. And it appears to me that the county is missing a huge opportunity to save money for other needs by refusing to consider teleworking as an option. We often hear comparisons to the state of Oregon and that we can't compare ourselves to their practices. However, to ignore the practices of the largest competitor for employees in the area seems totally illogical. We recognize that teleworking does not work in every situation. However, there are many areas that it can work effectively and efficiently. About the state, sorry about that. I'm aware of one of their departments that has made such effective use of remote telemarketing or teleworking that they have actually given up their office space. It's been taken over by another department, saving the original department several $100,000 in their budget. That's not pennies, that's a huge amount. They have a drop-in area for their use when they need to be in the office. Economically, the use of teleworking would be a great money-saving tool for the county. We already have the infrastructure in place, with laptops being the norm, and the addition of Teams and Microsoft to keep our camaraderie and rapport working effectively. It would promote retention and hiring opportunities. We could use our space more effectively, making the need for buildings a lower priority and leaving more funds for other uses. I'm sure each one of you have a wish list of projects that need funding, and this would certainly play into that. In closing, please understand that we are appreciative of the terms agreed to within the contract. We didn't get everything we wanted, but I don't think either side expects that. I hope that we are able to work more collaboratively in the future. The employees have shown their commitment to the work they do and the constituents of Marion County. I hope that you share those feelings. Giving true consideration to teleworking would definitely show your increasing commitment to your employees and your constituents as well. Thank you.
Thanks, Diana. Have a great day. And that looks like the last person signed up is Ilani. And then if you would, could you spell your last name for me, because it didn't make it to the sign-up sheet?
Sure.
Thanks.
Speropulos.
Is it S-T as in Tom?
P as in Paul.
Thank you. Okay, so now introduce yourself for the record. Tell us where you live and your purpose of testimony.
All right, thank you. My name is Eleni Speropulos. I live in Donald, Oregon. So I'm here to discuss a telecommuting policy. So I'm a mental health therapist within the county. I serve people that are struggling right now. Our community is struggling with many issues related to the pandemic, housing, inflation, many other issues. So there's a high need for people to get services at this point. And one of the problems that's happening is difficulty finding therapists that want to work here. Part of that is the lack of flexibility. Especially with the pandemic, people having their own families, needing to have more support and able to come to work and do the work that they love so very much. And we've had lots of high turnover within this time as well. And so that makes serving the community much harder. So telecommuting is very important for the mere fact that it would allow people to have flexibility, especially when they have to take into account their own costs for gas, especially at this point in time, and finding things that work for them and their families so they can continue to work. So when we're looking at telecommuting, it's not just for the employee themselves, but it's also for the people that we serve, and also to save the county money itself, because since we have the computers and the laptops and the cell phones and all the things that we need as of now, it's not the investment in that, it is the investment in the employees themselves to be able to do the work. So if we're allowed to have some sort of telecommuting policy or hybrid policy, that could definitely save the county more money in the way of building costs, utility costs, everything else that goes into having employees come to work every day. So if we're looking at the investment in the community, more money could go towards the customers that we serve rather than just the buildings and the infrastructure that we currently use now. So that's a big part of it. And I've talked with many of my colleagues about this issue, and a lot of them cite their own needs for telecommuting. And some of them couldn't be here today for various reasons, but the vast majority of people I've talked to support it, even if they can't use it directly themselves. So it's one of those things that would make a difference in retaining employees, and that's been very difficult. So I think that would help in the future, in general, to be able to provide the services that we provide in a quality that is good for everyone.
Great, thanks for coming today.
Thank you.
All right, and that completes our public testimony. For those that have signed up, is there anybody in the audience that came late that would like the opportunity? Great, hearing none, we're gonna move on with our agenda. And if we could move the consent calendar, and then I will ask for, actually I need a motion to move up 2 items. Items number 9 and 10.
Madam Chair, I will make a motion to move the human resource item number 1 and item number 10 to the front of the agenda. Is that what you need?
Yeah, it's item number 9 and item number 10.
10.
Okay. Item number 9 and 10?
Correct.
Okay, I will second the motion.
Great, I have a motion and a second. Is there any discussion?
Yeah, just to clarify, is my motion to put it right after the consent agenda?
Yes.
Okay, so it'll be the first item under action, the first 2 items under action, 9 and 10.
Correct. Okay, no further discussion? Hearing none, all those in favor, please say aye.
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 Aye, the motion passes. So Commissioner Willis, would you please move the consent calendar?
I do, but could Tim come, I have a question about the resale recapture.
Yes.
That could be in further discussion. Or
So do you want to hold on a motion or you want to talk to
Yeah,
him
why
first?
don't I ask
Okay,
him first?
perfect.
Tim, I was just
Wait, he
taking,
needs to introduce himself,
I'm sorry.
please. Thanks.
Tim Glisson, CDBG Home Program Manager.
Tim, I was just looking at, so one of the things in the consent agenda is we have a whole bunch of resolutions for the CDBG and home program. We're setting up, as a part of that program, there is a down payment assistance component. And so we're considering some rules around how we're going to manage that program, right? It looked like the current limit on the amount of down payment assistance that someone could apply for is $25,000, but that the board could increase that up to $40,000 in the future. Is that at our discretion, or would we have to amend this policy in the future?
You would have to amend the policy if there was ever an increase.
Okay, and then there's also a recapture provision. We're meeting with some folks later in the month to talk about sort of practically how this kind of a program can be successful. If we want to change the amount of the recapture as part of that, we would have to amend this policy again, is that right?
Correct.
And what's the administrative burden on that? If we say we want to amend this policy, is that something that you can do in a month, or is it like 6 months? What does that look like once we approve this?
Less than a month.
Okay.
It would be just another resolution.
Okay,
before you do it.
fabulous. Those are my questions. Thank you,
Okay.
Madam Chair. Thank you, Tim.
Thanks, Tim. We'll see you later.
Okay, Madam Chair, I would move that we approve the consent agenda. Under Board Committee Appointments, Marion County Mental Health Advisory Committee, approve an order appointing Nili Asades, I probably got that name wrong, I apologize, Nili, to the Marion County Mental Health Advisory Committee with a term ending June 29th, 2026. And then approve resolutions adopting the Community Development Block Grant and Home Investment Partnership Program manuals, policies, plans, and procedures for the following: the CDBG Program Manual, the CDBG Program Manual for Public Services, and the CDBG Acquisition and Construction Projects Program Manual, the Home Program Policy and Procedure Manual, the Affirmative Marketing Policy, the Violence Against Women Act Transfer Plan, the Residential Anti-Displacement and Relocation Assistance Plan, the Limited English Proficiency Plan, and the Section 3 Plan. Approve a resolution adopting the program year 2021-2022 recapture resale policy. Approve a resolution adopting program year 2022 through 2023 annual action plan under the Community Development Block Grant and Home Investment Partnership Program. Under Public Works, approve resolution initiating an amendment to the Marion County Rural Zone Code to operate an event business as a home occupation in the exclusive farm use zone, the special agricultural zone, and the farm timber zone, and schedule a public hearing for August 3rd, 2022. And under the Sheriff's Office, approve Amendment Number 3 to the contract for services with Communications Northwest to add $5,829.29 for a new contract total of $282,102.66 for unforeseen expenses not included in the initial quote for the Marion County Jail Radio project and extend the term date to June 30th, 2020.
I'll second the motion.
A motion and a second, and is there any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye, the motion passes. Now we'll move on to our adjusted action items, and Salvador, if you'd please join us. We're going to move into Human Resources to consider approval of the ratification of the Marion County Employees Association, MCEA, Collective Bargaining Agreement, CBA, for 2022-2024.
Good morning. Good morning. For the record, my name is Salvador Llerenas, and I'm the Labor Relations Manager. I'm here today to request approval for the ratification of the MCEA bargaining agreement that comes into effect July 1st, 2022. You have in front of you, the changes to the collective bargaining agreement. To highlight some of the changes, in Article 4, we did some cleanup in reference to 7.5-hour shift, and make some clarification on the modified work hours. On Article 6, we added Juneteenth and the list of holidays. On Article 7, we clarified when vacation starts. On Section 1, on Section 5, we make reference then the 5 days into 40 hours, and clarified on Section 7 the what is a unit. Under Article 10, we increased contributions for the health benefits for our MCEA staff. Under Article 11, we provided for call during the bargaining process, and added a differential for work performed by the mobile crisis unit while working with law enforcement. Under Article 14, we added then the per diem will be equal to the one provided by the IRS. Under Article 15, we work together on a good policy between the Juvenile Department and MCEA. Under Article 17, we added language, then the employer will not influence union membership. Under Article 20, we added some steps on documentation to be copied to the bargaining leadership. Under Article 21, we defined working days, clean up some language, and added types, clarify the types of disciplines, all clarification points. Under Article 24, we clearly define the layoff language. Under Article 26, we clarify when the initial trial begins. Article 33 speaks of the term of the agreement, and then we move into the letters of agreements. Then we renew the floor position, the journeyman cards for trade licenses, the Oracle pay incentive, sick leave conversion, and standby pay. In addition, we provided a pandemic recognition pay to the bargaining unit. Those are the changes. Are there any questions?
Commissioners, do you have any questions?
I'm just glad we got the boot policy updated there. That seemed to me to be something that was pretty reasonable, so.
Yes, we work and it's into effect July 1st. Absolutely.
Madam Chair, I'll just say that I think this is a really good timing. I want to thank staff as well as the members of the union who came to this agreement. These are difficult times for all of us. I think this prepares us for the next 2 years, and we all know what we're going to be. So really appreciate the hard work that everybody put in to get to this point. So thank you. And if you're ready.
I'm not. I just wanted to say, I wanted to echo some of Diana's comments from earlier. This is my first actual collective bargaining process as a commissioner for Marion County. I had heard from employees that were on bargaining teams before that it was kind of a treacherous process, and this one seemed to be expeditious and I suppose as delightful as it possibly can be in bargaining. And I just think that that is a testament to the will and motivation of the employees on both sides of the table to try to come to terms of agreement that produces compromises that are healthy and accepting, so things that you can live with every day in your job. And I really am grateful for that. And I'm grateful for your participation and your willingness to communicate so politely and regularly. So thanks to everybody who did really hard work in such a quick period of time. Hopefully it can be repeated in the future. Now I'm ready for a motion.
All right, Madam Chair, I'll move that we approve the ratification of Marion County Employees Association, MCEA Collective Bargaining Agreement, CBA, for 2022 through 2024.
I'll second the motion.
We have a motion and a second. Is there any further discussion? Hearing none, all those in favor, please say aye.
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 The motion passes. All
Thank
right, Salvador, you're just going to hang out with us?
Yes.
Great. We're going to get to that section of the agenda. Now we're going to consider approval of the ratification of the Oregon Nurses Association, ONA, Collective Bargaining Agreement, CBA, for 2022-2024.
Thank you. So, again, for the record, my name is Salvador Llerenes, and I'm the Labor Relations Manager. I'm here to request the approval for the ONA bargaining agreement effective July 1st, 2022. Jumping into the changes under Article 4 of the ONA contract, we clarified in the potential establishment of 410 work weeks and with 15 calendar day notice. Under Article 6, we added Juneteenth as the list of holidays being offered to our employees. Under Article 7, we clarified when the accumulation of vacation begins. Under Article 10, we provided an increase on the health contributions for the ONA members, our employees. Under Article 12, we have the COLA increases. Under Article 19, we define working days and how the formal grievance should also go to human resources. Under Article 24, that's the life of the agreement for 2 years. And then into the letters of agreements, we have the sick leave conversion and the pandemic recognition pay given to our ONA members. So I ask for the approval.
Any questions, commissioners? Hearing none, I'll take a motion, Commissioner Willis.
Okay, Madam Chair, I would move that we approve the ratification of the Oregon Nurses Association Collective Bargaining Agreement.
I have a question. I'm sorry. I see on my notes a typo, and I just want to clarify it before it gets.
I assume you're clarifying with James, so go for it.
Yes, we have under Article 12, it should say 5 on the COLA for the first year. It is? Yes.
Yeah, it does.
5. Okay, apologize, my,
No, it's okay.
It's very sad, because I looked at it, it looked like 6.5.
Yeah.
oh, yes.
There's a
I
colon
apologize,
though.
I see it.
Yeah.
My apologies.
No, it's okay.
I apologize.
That's a great catch.
Yes, I apologize.
Right, it is fine.
Yes, it was too close. I said
Okay.
C.
What page are you
Good
guys on?
clarification.
And just on page 2. No,
It's on the summary.
Yes.
Where it says, under COLA.
Yes.
Oh,
wages.
section 6. I got it. Okay.
The COLA is small.
In the summary of changes.
Yeah. Do you want my readers? Salvador?
I may need
Just
them.
kidding, I don't have those.
Yes.
Okay. I'll try it again.
Okay.
Madam Chair, I move that we approve the ratification of the Oregon Nurses Association Collective Bargaining Agreement 2022 to 2024.
I'll second the motion.
A motion and a second. Is there any further discussion? Hearing none, all those in favor, please say aye.
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 Aye, the motion passes. Thank you,
Thank you.
Salvador. Thank you, Angelique.
Thank you, thank you.
Nice to see you. I think we'll move through pretty quick. All right, so for the members of the audience that are here for the public comment, we have a few action items on our agenda that we need to get through. So it'll hopefully be 10 or 15 minutes before we start that public hearing, so you'll get to learn about the county. So we're going to move into our first original action item under Board of Commissioners to consider approval of the Community Development Block Grant subrecipient agreement with the Center for Hope and Safety in the amount of $250,000 for the Hope Plaza construction project through December 31st, 2023. Tim.
Good morning, Commissioners.
morning.
Again, Tim Wilson, CDBG Home Program Manager. So before you today for consideration is the subrecipient agreement for Center for Hope and Safety for the construction of Hope Plaza. Within this agreement, the county would be reimbursing Center for Hope and Safety for architect and engineering fees and permit fees in regards to the public facility portion of the building that will be built. This is in alignment with the consolidated plan and the annual action plan that was passed by the Board of Commissioners last year. And then in terms of what Center for Hope and Safety, they will have to annually report to the county in the terms of the number of clients that are assisted that are within our entitlement jurisdiction, which it does not include the City of Salem and the City of Gates. Because the City of Salem has their own program, and currently the City of Gates is not part of our program. And if there's any other questions, that's all I've got.
I don't have any questions. While this is a large contract, I just want to shout out to the contractor that their timeline, their buildable timeline is awesome. It's literally like day and month and year as to how they're going to make progress in the build. I've never seen anything like that. So, I mean, it's motivation, if nothing else, for their subs to be on time because they just published it on the record for the public.
All right, you ready?
Yep.
Madam Chair, I'll move that we approve the Community Development Block Grant subrecipient agreement with the Center for Hope and Safety in the amount of $250,000 for the Hope Plaza construction project through December 31st, 2023.
I'll second the motion.
A motion and a second, and is there any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye, the motion passes. Thanks, Tim. And next, we're going to move on to the clerk's office to consider approval of amendment number 8 to the contract for services with Avenue Insights and Analytics LLC to add $240,000 for a new contract total of $2,091,853 for services related to land records management system licensing and recording project and extend the term date on June 30th, 2023. Bill and Brian, nice to see you today.
Good morning.
Good morning.
Good morning, Commissioners, and thank you. We're looking at a contract extension here for a year with certainly provisions for longer if need be, but also to be able to cancel the contract within 60 days if we make a selection and move on to a new system, which we're hoping to do. We're working at the RFP proposal right now. I believe it's just about all graded. There may be need to get more information from some of the proposals. We had some really great proposals. I think we have 8 proposals now on the table, and we certainly want to get the right new system for Marion County. The timelines on some of those proposals are somewhere between 9 months and longer to actually institute any of those particular systems. Our one system right now that you've heard about the shortcomings of, because we can only have one person doing a recording at a time. Maybe the nice thing is that recordings are slowing down a bit now as the economy is slowing down a bit, and we think we can keep up during the interim period. Also, we've got a November election that we're working on and that we need to conduct. And then we'll, of course, have a May district election that we'll start working on probably in January. So we're doing things simultaneously, and with a lot of new staff, it's going to take a while to get this thing done and done right, but it's so important that it's done right, we need to take the proper time to do it. This gives us some of that breathing room.
I have a question, Madam Chair.
Absolutely.
So, Bill, the RFP was published on January 28th, 2022. It was closed on April 19th, 2022. And review of the RFPs began on April 29th, 2022. It's now June 29th, 2022. When will the review of the RFPs be completed? What date will they be done?
I'm not sure, hopefully soon, within the next few weeks.
Can you give us a date? Because it's been 2 months to review RFPs.
It's not our standard practice to spend that long reviewing RFPs, so I guess I'm confused as to what the hang-up is.
Well, when you open up an RFP for something as important and momentous as this, a decision to make, because we've been with one outfit and system for over 20 years through upgrades. Going to another system, we want to be sure that we get the right system and we get it configured properly, that the folks understand what we need and we understand everything that needs to be done. So that is not a real fast thing. It's not like going out and buying a pair of shoes or buying cell phone service or something like that.
I don't think the board
this
doesn't
big.
understand the complexity and the seriousness behind this software, but the county purchases necessary, really critical, important software all the time on kind of more of an expeditious process for the RFP. So I agree with Commissioner Willis that 2 months seems like plenty of time to review the submissions and make a decision, and then from that decision, go forward and work through the technical details of need and transition with that selected provider. Is it, Jan, am I wrong? Like, I guess I don't, I mean, we just purchased a health system and that's how the process worked. So is there a procedure that I don't understand in our system that kind of allows for this to be drug out? Because I feel like it's being drug out. And I also know our citizens who use this system feels like it's being drug out.
So, Chair Bethel and Commissioners, it is our standard process like you're describing. I think the holdup had to do with the election in May, and we agreed to not force them to do the scoring during the election.
Okay.
But I think after that, you know, we believe we should move forward with the scoring from the clerk's office and not wait till we're into another election again. So I'm happy to work with them and, you know, make sure we can get that on a timely basis.
The question, I'm looking at the contract, is there an out if we make a decision earlier, or do we have to go all the way through June?
They said 60
Yes, there
days.
is.
Right,
There is
there's a
an out.
60-day
Okay, good,
notice.
great, then I'm good.
And this is just for a 1-year extension.
Yes, 1-year extension.
With a 60-day
and,
out.
60-day notice to get out of the contract at any time.
Thank you.
I just want, Jan, Commissioner Bethel just talked about this contractor who had month and day of when things were gonna be done. This is a really important system for our community. It makes me uncomfortable that we're talking about next year's elections as potentially impacting this. I think people would be very upset if, I mean, this process is gonna already take well over 6 months. I'd like to have a date when the review is gonna be done and scores are gonna be issued, and then I'd like to have an implementation date.
Because I agree with you, the time to actually implement the system is before the next election. So I think, I don't know, with the clerk we could probably get it done within 2 weeks.
Oh,
Scoring on
oh,
your
sure, the
side?
scoring. I believe the scoring's already done, and we need to come together and talk about the scoring and figure out our next steps, where we need to ask more questions, and maybe have demonstrations and all of that.
So the scoring's done from your staff and from yourself then?
Yes, as far as I'm concerned, yes.
We could move that in a couple weeks.
So you'll get us a date
Yep.
for a close of RFP review?
Yes,
Okay.
yep.
And then we'll get a date for,
I'll participate on the group with the clerk and with IT on moving the process forward. How's that?
that would be
Perfect.
great.
Thank you.
All right.
Okay. Do you have any additional questions? Thanks. Thanks for both for you to be here today.
Sure. And if you have a moment, I'd also like to talk about our recount for just about 30 seconds.
So I need to close this action
Sure.
item first.
Okay.
Okay, Madam Chair, I move that we approve amendment number 8 to the contract for services with Avenue Insights and Analytics LLC to add $240,000 for a new contract total of $2,091,853 for services related to the Land Records Management System licensing and recording project, and extend the term date to June 30th, 2023.
I'll second the motion.
The motion and a second. Is there any further discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Motion passes. 30 seconds.
Thank you so much, Commissioners, for that. The election, we had about a 35% turnout on this particular election. We received over 76,640 ballots. We counted 75,419 ballots. 458 came too late, and another 765 still had signature issues that weren't able to be resolved. But then we did the recount. We did a recount. The Secretary of State asked us to count 2 races, the district attorney race and the appellate judge position 8 race. We went through about 3,000 ballots to do that, and the count for the precincts that we looked at ended up being exactly the same as the machine count. Further, we did a recount of the Salem City Council Ford Ward 4 race with we went through 6,141 ballots by hand. We had 3 teams of 4, or 12 people, working most of the day to get this all accomplished. And in that election, our hand recount, again, was exactly the same as the initial count, showing that our procedures and our equipment are working well for that. I am still getting requests for information for the November election. We just got one this last week, I just aware of today, where their person is asking for copies of all the ballots and then something electronic called cast vote records for all of these. We are figuring out just how we should respond, and if there's a way to respond in a way other than re-scanning all the ballots. That would be a very expensive procedure for that particular request for proposal for the November 2020 election. Another big thing in our department right now is retirements. We are losing or retiring, I guess losing may not be the right word, but we certainly will need to be replacing some more key people. Cheryl Hawkspear, who has been with us 30 years, after 20 years in the military, retiring as a sergeant major there, is now retiring with us as of tomorrow. And Patty Butler, who works intimately with her with some of the back-end processes, is also retiring. So we certainly have some team building to do.
And it sounds like you're going to eat some cake.
Yes, we'll have cake tomorrow.
Thank you,
So come
Bill.
on by.
Yeah, thanks for that information. hopefully folks are tuning in. Last week, Brian gave a brief overview of some of the same information, and you've added more data, and I appreciate that. It's great to be transparent with the citizens on our elections, and good luck on determining how much it's going to cost to fulfill that request, because it sounds like a big one.
You bet. And we are so happy to have Brian on our team.
Good. Thank you. Have a great day. Now we'll move on to the Juvenile Department to consider approval of Amendment Number 9 to the contract for services with Trinity Services Group Incorporated to add $150,000 for a new contract total of $550,000 and extend the term date to June 30th, 2023 for food service management services. Troy.
Good morning, Troy Gregg, your Juvenile Director. Thank you for having me this morning. And you just read right through what I'm going to ask for.
I mean, it's my job.
I won't repeat that, but you did a fantastic job. Just FYI, Trinity provides the lunch and dinners and snacks for GAP and detention in our facility. So this is an extension of the one-year contract to hopefully get everything kind of lined up on what we want to do to move forward.
Perfect.
Any questions?
Any questions? Great, then I'll take a motion.
Yeah, before I make the motion, I remember doing a ride-along with the juvenile crew and weed eating. In fact,
It's that time again. if you
I
care
was
to
out
ask.
at the transfer station last week and it is bad.
Maybe you can get some new boots and go
I
along.
don't
It's
think
a
that's
juvenile
good.
contract.
Lovely.
Weed eated since I went out there and weed eated with them, but the sandwiches came from that program. And I was plenty taken care of, so thank you.
There you go. You're welcome.
All right, enough of the sidebar here. Madam Chair, I'll move that we approve Amendment Number 9, the contract for services with Trinity Services Group, Inc., to add $150,000 for a new contract total of $550,000 to extend the term date to June 30, 2023 for the food service management services.
I'll second the motion.
I have a motion and a second. Is there any discussion? Hearing none, all those in favor, please say aye.
Aye.
The motion passes. Thanks,
Thank
Troy.
you.
Have a good day. All right, and our last action item for today is under Public Works to consider approval of Amendment Number 2 to the Agriculture and Engineering Professional Services Agreement with Dowell LLC to add $370,316.36 for a new contract total of $1,172,879.28 to restructure the existing preliminary engineering and construction engineering tasks, add the final design tasks and deliverables for the North Fork Slide Stabilization Project, and extend the contract through July 31st, 2025. Hi, Lonnie.
Good morning. For the record, Lonnie Radke, Public Works. Today, we're here to talk about the North Fork Road Slide Stabilization Amendment. We've been here a couple of times, but I just want to give a little bit of an introduction or a background. There were 4 slides that occurred on North Fork Road, and one was addressed about 10 years ago, so we have 3 remaining between milepost 4.9 and 5.5. We entered a project where we had a consultant, we had Dowell, looking at the geotechnical analysis, concept designs for all 3, and cost estimates for all 3 slides. Slide number 2 was identified as the greatest hazard and the largest cost. It was also determined to be the biggest need. So we went back to Western Federal Lands and requested more money to address the needs at slide 2. And we were successful at getting an additional $3.1 million. So as part of that, we need to also add a little bit more money to the design contract with Dowell. So this will include a number of things to get us through final design, environmental, and right-of-way phases, including the permitting, drainage, design, utility coordination, roadway design, traffic engineering, cost estimating. So today, we are requesting that we can amend the Dowell contract from $802,563 to add $370,000 from the $3.1 million so that we can get us through to the finish line, which would occur in 2025 and 2026.
Fantastic.
Questions?
I have none. I'm thrilled that this is moving ahead.
Yes.
It's like increments, each time it's a little exciting, but.
We're getting closer.
Yeah.
The additional money is huge. And this was known. We knew we would be coming to you for this because getting another $3.1 million to get us through to address slide 2 requires more design.
Yeah. Makes sense.
Yeah. You want a motion?
Yes, I do.
It'll be 12 years since I've been here when this gets done.
I would like to add that the capital projects team is
It's a tough one.
it is a really tough one, and we are getting so much work done, so much more work done than we have previously. We are close to fully staffed. In fact, we're adding a couple of new positions, and we are just, everybody is working at great capacity levels. They're doing a lot of hard work and getting us these projects that are older projects, getting them through to the finish line.
And Madam Chair, I didn't mean that as a criticism. I just
But
meant
it's
that this
the
is a
relief.
tough deal. And that slide's happened a couple of times, and it's got to be done right. It's got to be done right. So it's great that we got this
Working with
done.
the federal government's super easy, Commissioner. I don't know what
Oh
you,
my
why
gosh.
do you think that's so hard? I don't
Well, and
get
it's
it.
not like they had
Thank-
an ice storm or a wildfire
Yeah.
and that, took them to the
Or-
knees.
Or COVID.
There's been a lot.
But,
Yeah.
but thank goodness
really-
this is on a road up to a federal, up to Opal Creek, so you can get these kinds of funds. If it was someplace else, it'd be tough.
It's one of the few places in Marion County that we can get the western federal lands, and Oregon has been successful. We've gotten the most western federal lands funding in the whole country.
Wow.
So, yeah, it is
Well done.
fantastic that we have this opportunity, and we're looking for more. But I really just want to give great compliments to the capital projects team for all that they have done to get us here.
That's
Ryan
fantastic.
Crother, and this is also Mark Foster, and it's a lot of work that they're pushing through, and it's very impressive.
Well, good. Go back and say thanks.
I
Give them
will.
high fives.
I will.
I'm sad Ryan's not here to help push your little go buttons. All right, I'll take a motion because we have a public hearing I'd like to get to.
I think it's, Commissioner, I guess it's mine. Madam Chair, I move that we approve amendment number 2 to the Agriculture and Engineering Professional Services Agreement with Dow LLC to add $370,316.36 for a new contract total of $1,172,879.28 to restructure the existing preliminary engineering and construction engineering tasks, add the final design tasks and deliverables for the North Fork Slide Stabilization Project, and extend the contract through July 31st, 2025.
I'll second the motion.
I have a motion and a second. Any further discussion? Hearing none, all those in favor, please say aye.
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 Aye, the motion passes. Thanks,
Thank you
Lonnie.
very
Have
much.
a great day.
You too.
And now I'm going to recess the general meeting and open a public hearing to consider an appeal of the hearings officer's decision denying administrative review, case number 21-038, Joshua Fogarty. Lindsay, would you please join us? Thank you. All right.
Good morning, Commissioners. For the record, this is Lindsay King, Marion County Planning. The item before you today is an appeal of the hearings officer decision denying the application for an administrative review to determine whether a Measure 49 remains valid on a 13.53 acre property consisting of 2 tax lots in the exclusive farm use zone. On January 21 of this year, the planning director issued a recommendation of denial based on available evidence that the 10-year time limit expired on June 14th of 2010. The hearings officer held a public hearing on March 10th of this year, and the record was left open until March 31st. The hearings officer then issued a decision of denial based on all submitted evidence on May 13th. That decision was appealed to the Board of Commissioners on May 31st of 2022. In the In the executive summary on the second page of the decision, the hearings officer stated that the 10-year timeline had expired on June 14th of 2010 at the conveyance of the subject property to the beneficiaries of the trust it was held under. The hearings officer concluded that the distribution of the subject property from the trustee to the beneficiaries by warranty deed, June 14th, 2010, did trigger the development clock, and that no dwelling was established within that time frame. This rendered the Measure 49 void, and the subject property is no longer eligible for a home site through the Measure 49 order. In the appeal, applicants list 3 items that are the grounds for their appeal. The first one is the hearings officer interpretation of owner as used in Measure 49 contradicts the text and context of applicable Oregon law. 2, the death of a claimant does not affect Measure 49 rights. 3, a conveyance from a trustee to the claimant and current owner of the property does not trigger the 10-year period. These are the options that the board must consider. Remand the matter back to the hearings officer, requiring an agreement from the applicant to extend the 150-day decision-making deadline. 2, deny the request and uphold the hearings officer decision denying the request. Or 3, approve the request, stating the facts and evidence upon which you base your approval. And I'd be happy to answer any questions you might have.
Thanks, Lindsay.
I have a question, Madam Chair. And Scott may want to answer this one. So in reading the hearings officer's decision, on page 14, the hearings officer says, applicant correctly states that if the trust had not existed, the right to prosecute the Measure 49 claim and establish a home site on the subject property would have passed to living children of Mary Rule Dodds without triggering the 10-year development period. Do you read that? Do you see that place, that sentence there on bottom of page 14?
And before you answer, please introduce yourself for the record. Thank you.
For the record, this is Scott Norris with the Office of Legal Counsel. Yes, I see that. I note let's see, I'm trying to find the passage. I'd seen that. Yeah, I know that paragraph does conclude with, but the trust did exist, and that right passed to the trustee when the trust became irrevocable.
That's
In other
right.
words, at the death of the
And that's where the disagreement lies. But that first sentence, the reason she says that is because of Section 10 of Measure 49. Is that correct?
I would believe that's correct. It doesn't say that expressly here, but I believe that's correct.
And that says if a claimant is an individual, the entitlement to prosecute the claim under Section 6, 7, or 9, Chapter 424, Oregon Laws 2007, and an authorization to use the property provided by a waiver under Section 6, 7, or 9 of Chapter 424, Oregon Laws 2007, is A, not affected by the death of the claimant if the death occurs on or after December 6, 2007, and B, passes to that person that acquires the property by devise or operation of law. So if we find that the property in this case passed to Gretchen Ryan and Justine Fogarty by devise or operation of law, then the triggering event wouldn't be June 14, 2010. The triggering event would be when Gretchen transferred her interest to Justine in 2015. Is that correct?
The key terms there in subsection 10 of Measure 49 is in subsection B, where it says, passes to the person that acquires the property by devise or operation of law. So the question is, one, what is the property that transfers? And in terms of operation of law, does, in the context of this case, does the death of the settlor of a revocable trust pass the fee title to the property in question to the beneficiaries by operation of law as opposed to by operation of the terms of the trust?
Right. So I just want to clarify, though. The reason why, if there wasn't a trust, that they would be able to develop this property is because of this Section 10. And so if we were to find that the claimant, in this case, is an individual, and that her death occurred on or after December 6, 2007, and that the property passed to the person that acquired the property by device of operation of law, then the applicant in this case could move forward and develop it, correct?
Yes, let me try to break that down a little bit.
Those would be the findings that we would have to make in order for the applicant to have a favorable decision from us, correct?
Correct.
Those are my questions.
Okay. Do you have any questions for Lindsay? Okay, don't go anywhere. We'll just call everybody else up here. Okay. All right, now we're gonna move on to the applicant's presentation. And I'm gonna go out of order operation from the sign-up sheet. Is that Alan?
Yes.
Sorum? Great.
I have, just to order business, I have some cards, both with the image of the property and then the text. Is there a preferred location?
Just put it next to you. So that way we're not blocked and neither are you.
What about the cameras?
Yeah, I think, I don't know how we would, they'll tell us if they can't see us. How's that?
We're all friends. It'll be fine.
It will be great.
Thank you for your patience while we set up. For the record, my name is Alan Sorum. My address is 250 Church Street, Southeast Salem, Oregon, zip code 97301, Suite 200. Attorney for the applicant, Joshua Fogarty. Appreciate the summary from legal counsel and Planner King. We do have kind of an interesting case here with, it comes down to kind of a narrow statutory interpretation. We're going to drill down into the text of Measure 49 and the context. And so I'm going to bring this over here. Not everybody, we're upside down. So first I'll start just kind of describing the property and a little bit about its history and also Marion County's history, because that context is really important to understand both the application of the law and the consequences of what we're deciding here today. So the Duck family acquired this property.
1 second. Is the microphone not on? Because it's right close to his face. Can you come check?
He just turned it off accidentally.
Go ahead and push the button in front of you. Perfect. Thank you.
Thank you, sir.
Okay.
Okay, as I said, the Dodd family acquired this property in the 1950s, late 1950s. Norman Dodd, he was married to Mary Dodd. And at that time, this was all in the county, and there was no active zoning in the sense that we think of zoning today, restricting, most importantly, the right to be able to develop a home on one's house. Right here you see in blue are the current city limits, or excuse me, the urban growth boundary for the city of Silverton. This area in brown is zoned urban transition. Farther to the east is a large tract of AR land. In the 1970s, all of this land actually was zoned AR. And the date of acquisition for the purposes of the Measure 49 claim, or 39 claim, was deemed to be 1979. The Dodds had done some, even though they had acquired the property originally in the 50s, they'd done some estate planning work. In the 1970s, it was common if a husband and wife owned a property and they needed to do some estate planning services, and it would be more beneficial to have it in the name of one spouse as opposed to another, they would transfer it to a straw person, often a legal secretary of an attorney, and then they would transfer it back. So Norman Dodds reacquired the property in 1979. At that time, it was zoned, as I said, AR. It was almost a 14-acre tract. DLCD said, while it was zoned AR at that time, it was subject to the interim statewide land use planning goals. So there was a period between 1973 and 1981 where the state had their first draft of statewide planning goals, and it was really confusing how to apply them. And basically the state acknowledged this, and so they kind of created a rule of thumb. They said, hey, if if your property is less than 20 acres, we'll say you could have put at least one house on it. And then if it was bigger than 20 acres, you could have gotten 2. And then up until like, if it was bigger than 80 acres, you could have gotten 3. So they kind of simplify the process through some amendments to Measure 49. But that's a little bit of the history. So just to summarize, the date for acquisition under Measure 49 was deemed 1979. This would have been zoned AR at that time. And the state acknowledged the family would have been able to do at least one home site approval. So Mary Dodds, like many Marion County citizens, many individuals, in 2006 applied for Measure 37 claim. That law was changed in late 2007. The state sent out notices to the claimant holder, said, hey, you got to refile. She did so in May of 2008. While her claim was still being processed, she passed away in October of 2008. It took the state until June of 2010 to finally issue its Measure 49 order. So
Sorry, when did she pass away?
October of 2008.
Thank you.
Just double check my notes, make sure. Yes, October 12, 2008.
Thank you.
So the good news is the state still granted the approval of the Measure 49 order. Wasn't what the family had hoped. They had hoped that they would have been able to realize that the family had actually acquired the property in the 50s, and at that time they would have been able to do pretty much any kind of residential development had they want. They could have done something like you see, a little bit higher density residential development in the AR land farther to the east. But they were resigned, and they had kind of this compromise, which is what the core of Measure 49 was. The state, when they issued the final order, and the footnote of the first page, they acknowledged that the state was aware that Mary had died during the time period in which the Measure 49 order was issued. The footnote said, under Measure 49, if claimant dies on or after December 6, 2007, that was the effective date of Measure 49. So if someone dies...
Can you repeat that?
It says, under Measure 49, if a claimant dies on or after December 6, 2007, entitlement to prosecute the claim passes to the person who acquires the claim property by devise or by operation of law. The state issued the decision kind of with the normal conditions of approval, and the Measure 49 order, it doesn't say it expires in 10 years. Okay, so the state knows that Mary has passed away. They've recognized that in the footnote of the decision. They've made permanent record of that. There's no doubt that they knew that. But they still issued a standard Measure 49 order with no statement that, hey, 10 years from now, this order is going to expire. So the family, the property was in a trust. Trust was originally established back in 1992. And Norman was a doctor. Mary was a stay-home mom. They used the benefit of commercial bank. So some of the longtime residents of the Willamette Valley will know that name. Commercial Bank is the predecessor to West Coast Bank, which is the predecessor to Columbia Bank. Banks merge, they change over time. We're talking about decades here. The benefit of that is you have this kind of stable institution that can go ahead, manage a bunch of assets, and help out the family in following the terms of a trust. Very, very common practice, especially when an estate's got several different issues going on, and there's a benefit to having someone professionally manage the trust assets. But, Columbia Bank or the trustee, they don't get to go out and make use of the property. They don't get to use and enjoy it. They don't benefit from the profits or share in the losses. They have a fiduciary duty, and it's the owners of the beneficiaries of the trust who are entitled to it. When Mary passed away, the beneficiaries were her two daughters, Gretchen and Justine. Gretchen and Justine under Oregon trust law, and this is where I'm going to kind of jump up and start going through some of the text that's important.
You'll still need the microphone, so Brendan, or maybe John in the back, can you get us a wireless so he can hold that, or a staff can help him? You can keep talking, just you'll have to hold that base mic at the same time. Thank you.
Yeah, so there's a couple provisions that are relevant as to, at the time of death, who's the owner. So Oregon trust law says that the beneficiary is the person, they have a present possessory beneficial interest in the trust, whether vested or contingency, and the Trust Act continues and says the interest of the beneficiary under a revocable or irrevocable trust vest when the trust becomes irrevocable. So when you have a trust and you set it up as yourself, you can go ahead and change it whenever you want. But when you die, the trust becomes irrevocable. It's not supposed to be changed, and whatever the instructions were to the trustee for distributing the trust assets, 50-50 to my 2 kids, you don't get to change that. But that's all that means. It's just, the instructions are going to stay the same now that the original settler of the trust has died. But the children, they are the ones, they're not trespassing if they're on the property. They're the ones that are, somebody still has to pay the property taxes, somebody still has to maintain it, somebody has to use and enjoy it, and the beneficiaries are the ones that have what we call equitable interest in title. Measure 49 is also relevant, and that indicated, there's a couple definitions of owner. The provision that was cited by the hearings officer in the state, it says that if the property is owned by the trustee of the revocable trust, the settler of the revocable trust is the owner. So originally Mary was the owner, they recognized that, and they said except that when the trust becomes irrevocable, only the trustee is the owner, which says, okay, well, West Coast Trust was the successor trustee, they are also a title owner of the property. But you got to read this law into context. This law doesn't supersede the Uniform Trust Code, which says that the beneficiaries are also owners. So the reason why I bring that up in the definition of the owner is it comes down to the core question of, well, what happens when someone dies, and we have a transfer of the property. And here is kind of the general rule. So first rule, very important. There is no time limit on when an authorization granted under sections 6, 7, or 9 of this 2007 Act must be carried out. So normally, Measure 49 orders, you get them, they don't expire. There's no expiration date that's built into a Measure 49 order. There's an exception though, except that once the owner who obtained the authorization conveys the property to a person other than the owner's spouse or the trustee of a revocable trust in which the owner is the settler, the subsequent owner of the property must create the lots or parcels and establish the dwellings authorized by a waiver under sections 6, 7, or 9 of this 2007 Act within 10 years of the conveyance. So there's a lot to unpack here. Because, the folks who were writing Measure 49, they were doing it in a time crunch and in a hostile environment. They were trying to broker this compromise. They didn't have necessarily the most clear language. But if you follow it here, we can break it down a little bit. So what we need to understand is that when someone conveys the property to their spouse or the trustee of a revocable trust, the 10-year period isn't triggered. So we understand that. That's a clear example. But what triggers this 10-year period? It's a couple things. It's when the owner who obtained the authorization conveys the property to the subsequent, then the subsequent owner must create the lots. That's the rule we're trying to figure out. So who's the subsequent owner and who's the owner that obtained the authorization? The hearings officer, by and large, agreed with what we were testifying in our applications, but as Commissioner Willis and staff kind of indicated, there is obviously a disagreement. We didn't get the result we were looking for. The subsequent owner, in the opinion of the hearings officer, was deemed to be Gretchen and Justine, the beneficiaries of the trust. Our position is they're not subsequent owners. They had a current possessory ownership interest in the property that was vested as soon as their mother had died. So before the Measure 49 order was even issued, that they were not subsequent owners. They already owned the property. That this is intended not to apply to a very kind of necessary transaction, or it's not really a transaction, a conveyance from the trustee, the fiduciary, West Coast Trust, to the beneficiaries. Under the trust, West Coast Trust has to go ahead and give them the property. It's irrevocable, there's no choice. They have this fiduciary duty, and you can have the idea of co-owners. So West Coast Trust had
Alan,
co-owners. Go ahead, yeah.
Can I just interrupt for a minute? Because I think this is like, you're really diving in here.
Yeah.
But I think something to just bring it back to sort of the issue is this section 10, right? Because in this case, just leave that up there, because in this case.
Okay, I have it here as well, and I want to get to that.
Because this here says the owner who obtained the authorization conveys the property to a person other than the owner's spouse or the trustee of a revocable trust, then the subsequent owner must, right?
Mm-hmm.
But section 10, and nobody disagrees about this, explicitly acknowledges a situation where someone other than the owner's spouse or the trustee of a revocable trust is not impacted by this, right? So I think really I think this owner thing is interesting, but I actually don't think it's dispositive in this circumstance, because the hearings officer already acknowledged that, right?
Mm-hmm.
The hearings officer already acknowledged that if Gretchen and Justine receive this property through a will, or if Mary died without a will, then that 10-year time period would not have run, right? And that's because of this section, right?
Yes.
So I mean, this whole owner thing is really interesting, but I think the actual operative section is this section here.
Right. I agree. This is because we're doing text and context, and this is also the text of Measure 49. And when we're trying to figure out, is that 10-year trigger happening or not? You don't want to look at it in a vacuum.
Yeah, I don't want.
I only had one board.
Okay, so I feel like I understand what you're saying.
Okay.
And I just want to be clear.
Yes.
Because this is riveting, believe it or not. And I'm just going to break it down in my non-lawyer layman terms. Because the mother died previous to the decision of Measure 49 coming through, you're basically saying that that's all moot. That the fact that she died and the trust took effect, we're not worried about the outcome of Measure 49.
Justine and Gretchen already were the owners of the property.
Right.
They were the claimants. They were the ones who obtained the authorization of the order. And any deed that goes to them, it's not material. It's not a conveyance that triggers the 10-year period.
Do you think I'm understanding what he's saying?
I don't think we have to say that, though, right? I don't think we have to, now tell me if I'm wrong. I don't think we have to make a determination on whether or not they were owners under this statute. I think the only determination we have to make is, did the property pass to them? Did they acquire the property by devise or operation of law? Right? If Gretchen and Justine acquired the property by operation of law, then the ownership analysis is irrelevant, right? If Mary is an individual, if she died after 2007, and if the people who inherited the property acquired it by operation of law, then
the 10-year period, there's no time limit. There's no time limit. Yes.
If you agree with that, I want to stick to that, because
you.
I don't want to try to make findings that are outside the scope of what's necessary for the applicants in this case to get the relief.
So if I'm hearing you right, to summarize, Gretchen and Justine, they were the claimants. They inherited by operation of law.
I would say Mary's the claimant.
Yeah, Mary was the original claimant,
Mary's
but
the claimant.
they inherited by operation of law their mother's claim.
Yes.
Also, not just her claim, because it says if a claimant is an individual, they inherit the entitlement to prosecute the claim, but also, and an authorization to use
That's
the
right.
property.
That's right, the
This
authorization
is
to
the
use
key
the property.
language.
That's right.
So
That's right.
Justine and Gretchen, they, under this section, they inherited it. And this is the most specific language in all of Measure 49 that applies to this case.
That's
And it
right.
says it's not affected by the death of the claimant. It passes to the person that acquires the property by devise or operation of
So
law.
in my mind, the only question is, could you talk a little bit about what operation of law means? That seems to be the operative language here. What does operation of law mean? If something passes to somebody by operation of law, what does that mean?
Operation of law means that even though there's not an express act, like I'm not signing a piece of paper, something has happened. Something, an event occurred, and because of the statute is written in a manner, an interest has moved around, or someone's interest has become vested by the way that we set the rules.
And in the case of the Uniform Trust Code,
Yes.
if someone has a trust, a revocable trust that becomes irrevocable upon their death, and they die, does their property, is their property conveyed by operation of law?
The beneficiary's interest in the property vests by operation of law. You still will have a deed that will clear title from the trustee so that the assessor office knows, and Mr. Burgess and the clerk knows that, the current owner of the property, the name has changed. But the ownership, the right to possess it, the right to benefit from it, and the ability to enjoy and profit, all of that by operation of law is immediately vested in the beneficiaries.
Upon the death of the settler.
Upon the death of the settler.
And that's a real property interest, correct?
Yes, it is. And that's
a real property interest.
That's a real property interest that's vested in the Uniform Trust Act expressly recognized.
And so the Gretchen and Justine acquired a real property interest by operation of law, the Uniform Trust Code, at the time of Mary's death. Is that correct?
That's correct.
Okay.
So we're all on the same page as up to that moment. We still, when we're doing our statutory analysis, we can't just ignore other statutes. So we kind of, knowing that this is the most specific language, this is the language that we're going to base our findings on if you agree with the applicant's request. Then we go back to the language about, well, is there something in here that would nonetheless say it's 10-year triggered? And we would say, no, the general rule will still apply, that there is no time limit. And these events they've not been triggered.
And the reason we know that is because if there wasn't a trust, and this was conveyed by a will, the timelines wouldn't apply in that case either.
Yes.
Because everyone agrees, including the hearings officer, that the more specific language controls over the more general.
Now, I do have to kind of speak to something that is in the record from DLC that came in this week, and in their footnote 2, they say, well, we also think that because Mary died, at the time of death, that was a conveyance. And it doesn't matter. They disagree. The state disagrees with the hearings officer. And they say, no, under any circumstances, the 10-year period would be triggered. And I strongly disagree with the state in that, because they're ignoring the plain language of the statute. In fact, in their footnotes 1 and 2, they cite, it's this one. They cite that the claimant inherits the ability to prosecute the claim, and they completely ignore and omit from their comments the fact that they inherit both the ability to prosecute and the authorization to use the property. And that's the fundamental problem of the state. I can appreciate if I was running, the department, I want as simple of a system as possible. You say, okay, well, if someone dies, it's 10 years, let's start the clock 10 years. But honestly, that's brand new. That is not what was being said at the time of Measure 49 was adopted. That's not what the Measure 49 order said. If that's really what the state intended, and when they issued the Measure 49 order, they knew that she had died before they issued it. They should have just said that it expires in 10 years, if they're going to try to draw a bright line rule. But they didn't do any of that. And so now, 12 years later, they're coming up with this kind of new justification of saying, well, we think, these statutes, it's 10 years anytime someone dies. But that ignores the plain text of this statute. And we can't do that.
Okay, Mr. Storm, two other things. One is, it seems like the hearings officer's position is that conveyance of the deed actually conveys the property to somebody,
Correct.
right? So the hearings officer's position is that the deed actually does it. Is that the case? Does the transfer of deed always convey property rights? Is that a substantive act or is that a ministerial act in your mind?
So it's kind of a complicated question because when we are in law school, and there's every single law school professor uses the same analogy to answer this question. Property is not a single thing. Property is a bundle of sticks, okay? When you own property, you own a whole bunch of stuff. You own the right to tell people, you can't come onto my property, basically enjoy it. You use the ability to access it. You use the ability to mine it or get profit from it. You have the ability to sell it, get a loan. You have all of these rights. And you can go ahead and transfer any one of those rights. But the two ways to think of it is there's who is the title owner, who is the person that the tax bill is going to go to, and then who has equitable ownership. This is what we think of as really commonly think of who owns the property. And that is the right to use it, to enjoy the profit from it, be responsible for the losses, to physically possess it. All of those interests transfer by operation of law on the moment of death to the beneficiaries. It is only the legal title that requires the deed to move from one person to the other.
And the way that we know this is because there's such a thing as a fraudulent transfer of a deed.
Yes.
Right? So if I wrote up a deed to something that I didn't own, and I recorded it with the county, the person that I transferred that deed to would not actually be the owner of the property, correct?
Correct. It would show it. You go ahead and you take the deed of my house and you sell it, on eBay for $5. I can, even though if it was recorded by Mr. Burgess in the county records, I could go ahead and get a court order and establish that I was the equitable owner. That was a fraudulent transfer, and that deed, even though it was signed, even though it happened, it didn't occur. Or more, if maybe I was incapacitated, and my name, I signed it under fraudulent circumstances. There's any number of events where a deed in of itself is not the trigger. So I appreciate your line of questioning, and I think it's really helped kind of clarify our position. It is this section 9 which is most applicable. And Gretchen and Justine were the owners of the property. They inherited both the right to prosecute the claim and use that Measure 49 authorization. It was not affected by the death of the original claimant, Mary Dodds. And under those circumstances, knowing that the general rule of the legislature was that the Measure 49 rights are not intended to terminate in any time period, and the state didn't say that on their Measure 49 order, there's no reason to have concluded that it expired in 2020.
But going back to the earlier section about the owner, that section is operative once Justine Fogarty transferred the property to Joshua Fogarty, correct? Because once Joshua gets that property, he is now the subsequent owner under that section 7, correct?
Correct.
So the time period would begin to run in 2015 when he received title to that property.
He received title in 2019. So the 2015 date was a deed amongst Gretchen and Justine.
Are you sure? It says on May 28th, 2018, Justine Fogarty transferred 100% ownership.
I'm sorry.
Was it 18?
Either way.
19?
It
Regardless.
says it's 2018.
The date that Joshua
yes.
received the property right, that's when the clock begins to
Absolutely.
run.
So we're not saying this doesn't apply to the Fogarty family. Of course it does. This statute does apply, but it applies when Joshua Fogarty acquired the interest.
I have a question.
Because he is the subsequent owner, yes.
And maybe it's for legal counsel. I don't know who needs to answer it. And maybe you already have, and I don't understand it because your legalese is way over my head. So in the hearings officer findings, number 8, she says, on or about June 10th, 2010, West Coast Trust transferred the property to Gretchen Rhine and Justine Fogarty by statutory warranty deed that was recorded on June 14th, 2010. A corrected deed was issued on April 17th, 2010. The corrected deed states, it is believed that this transfer from grantor to grantee will trigger that 10-year time period, and the final order will expire if the final order home site approval is not utilized by the grantee. Grantee takes the property subject to this. Doesn't that deed have to be signed and recorded by the recipient?
So, the recipient, no. The grantor, yes. It was signed by the West Coast Trust. It's not signed by the party who receives it.
But don't they have to communicate those documents to whoever the owner of the trust is? So my point is that doesn't the owner, who at this point, which I believe is Gretchen and Justine, have record, legal record, that a 10-year timeline has begun?
I was not the attorney who did that, and I have it's Exhibit 106, and I have that in front of me, and there's another sentence in that deed that I think is appropriate to understand as to your question. So it says, due to the uncertainty and the changing nature of Measure 49, comma, it is believed that the transfer of the grantor will trigger the 10-year period. So the party, even the drafter, the attorney who prepared that on behalf of West Coast Trust, didn't confidently know. That they were writing it in a defensive manner to kind of go ahead and avoid any claim back against West Coast Trust. Your question being, well, shouldn't the other party have known? I don't know. It is recorded in the real property records. It's available. But we're trying to understand how do we apply the law? Not necessarily what did they know or what should they have known. And Ms. Fogarty can come up and testify to her communications with DLCD following the issuance of the final order and asking a question about that and what their responses were. And the responses were that the 10-year period didn't apply to them. So I don't think that statement in the deed is conclusive in any way. And it certainly doesn't answer the question that is in front of this board, which is, what do the statutes mean? Because you all are the elected officials in this quasi-judicial hearing. It's your determination. What is the law? What is the effect of the death? That is what we're interpreting, and not necessarily a question of, well, what did you or should you have known?
Well, I appreciate that, but I also have to make findings if we decide to move forward that's defensible on an appeal.
Yes.
And so I need to fully understand the facts, and
absolutely.
I've never read a full deed either. I can't think of one single landowner besides lawyers that probably have. So, I'm not saying that you should have fully understood or read all those documents. My point is that our hearings officer specifically referenced that, and that matters to me in my findings, because I have to be able to make a confident decision to move ahead here. And I think it does apply to a point. But I also understand what you're saying, and I fully understand, as I described before, it's your position that the current circumstances of Measure 49 don't come into effect because the original owner passed away before the state's decision was finalized. So I'm there.
Thank you.
Okay.
I think it'd be good to hear from.
Yeah,
from your
so I would
clients
like-
about-
Well, just a sec. I want to make sure, Commissioner, do you have any questions?
Well, Alan, you mentioned that she did reach out to LCDC. When did she do that?
DLCD, I don't know the time, so she can kind of give the best of her reaction. That would be sometime shortly after it was issued, but many years ago.
Because the word believed makes me say, okay, I better check this out.
Yeah.
It doesn't say it's a fact.
I will ask Mr. Fogarty first to come up, and then his mother, Ms. Fogarty, to kind of come up and answer some of these questions. Mr. Fogarty's testimony is going to speak to there's another kind of, we've been doing a lot of talk about findings, and often in these cases, there's kind of the finding, and sometimes we'll make alternative findings. One of the alternative findings that we would ask the board to consider and grant is that the dwelling was established. The right to the dwelling was established prior to the expiration date in June of 2020. Because Mr. Fogarty is going to tell you about really kind of what his project was and how far that he got there. Because he acquired the land, he obtained a number of permits, he built an outbuilding that was part of his overall project to build the residence, and completed, more than 50% of the expenditures in that project, all in good faith, with the understanding that the 49 order wasn't going to be deemed termed out on him, and that was a surprise to him.
So let's let him do that.
Absolutely.
Thank you. You're doing a great job.
Thank you.
All right, Mr. Josh Fogarty, would you please come forward? Good morning. So for the record, please tell us your name and your address.
My name is Josh Fogarty, well, Joshua Fogarty. My mom's sitting here, so she prefer Joshua. And my address is in Silverton, and I'm the applicant on this property.
Okay.
Thanks for your time today. So I have to the Marion County Board of Commissioners, my name is Joshua Fogarty, the applicant in the case. I'm the last living male heir from the Dodds family. My grandpa Dodds was a doctor in Silverton. He saw patients in his and my grandmother's home, which is now on a separate 3-acre parcel next to mine. The estate sold this neighboring property decades ago with the idea that a family member would build a home where I began to build one. I was born and raised in Silverton. I've been playing, scouting, hunting, maintaining, and developing this property that is in discussion today for 45 years, as I'm the last living male there, and the gals didn't like cleaning fence lines and pulling Scotch broom and stuff like that. Immediately after buying the land, I did pull multiple permits and invested my life savings, around $300,000, to get this property to the point where my wife and I could fulfill my dream, and that of the family members, to build a house on my family's property in the location everyone in our family always wanted to have a home. I planned on borrowing around $300,000 to build the home. I'm at least halfway to that budget that I had, and we all have budgets. I had a rough number in that. No one has or ever will farm this ground, as it is poor farmland. I permitted and invested in building a driveway. I permitted and brought in 440 amp power service after applying with PGE to service a pole barn and a home on the PGE plan that I had to pay for. I permitted and built a septic system that could service both a pole barn and a home, with the county making me take up more land than a septic system only for the barn would have. I permitted a well and filed with the state. This was a huge expense alone, just under $50,000, that I only obtained to build a home on the property and never would have pursued had I known I could not build my home. I have installed all the infrastructure and the utilities required to build a home. I had budgeted once again around $600,000 for this project, and I'm at least halfway into that. I regret I wasn't able to pull final permits for my home before the deadline DLCD and the hearings officer believe applies to my property. The fires, ice storm, worldwide pandemic with its staggering material prices and lack of contractors, me being one of them, to perform work all played a role in my delaying to file for the home permit. I heard about similar delays in the North Fork project. I get it. I bought my house plans from Highline Homes in November of 2019, and multiple tragedies locally and worldwide set in. And even if I had filed earlier for the home building permit, I may not have met the deadline that has been imposed. I do not agree with so-called Friends of Marion County's claim in its comments that getting permits and inspections has not been affected by the pandemic. It has been negatively affected in my experience, and I file for them regularly as a licensed contractor. I have had countless delays in all areas of getting permits, inspections, and final approvals. The hearing officer recognized the above listed issues, certainly with the COVID delays. If I had thought that a deadline was looming, I would have acted quicker, as I'm a licensed general contractor in the state of Oregon. To me, this shows I was human and made a mistake by not knowing or interpreting the verbiage, which I don't think all of us completely do either. on Measure 49 like DLCD and the hearings officer are now trying to do. I'm not asking to develop farm ground, I'm asking to build a house on Class 6 soil that my family had not managed in any meaningful way for decades. I just want to be able to continue to maintain the land, use it, let my family enjoy it for gatherings and holidays. I want to mow the old field in front of my new home with my Grandpa Dodd's old Massey 35 Deluxe, which I still have. In the same field, I rode that tractor with him. All I want to do is honor my grandparents' wish that the property remain a home site in the family. Thank you.
Thank you. Do you have any questions? No. Jane? Don't go.
And this might be for Alan. Was this this finding that the dwelling was essentially established made before the hearings officer?
Not in the detail that we're speaking to, but it's definitely part of the Measure 49 order.
I'm sorry. Can you either come to the front or give him that microphone? Because we have to have the public participating. Thanks.
A lot of this is in our original application materials. Yeah, so, but my understanding is a de novo hearing, and so we're able to introduce any kind of arguments.
No, and
Oh,
that's
yeah.
not what I was going at. What I was going at was a potentially option for the board if they're interested in pursuing this. This could be remanded back to her with an extension if you wanted to make that argument. I don't know if it was raised.
We didn't focus on it. We did touch upon it, but, our primary argument was regarding the text of that. But, we wanted to go ahead and present kind of everything. When you're in front of the hearings officer, sometimes things come in piecemeal in the record, and today is kind of our final summation.
So the facts were there before the hearings officer, but
Yes,
but
all
the
the
argument wasn't necessarily.
the permit record history is all in the original timeline of the narrative statement, and there was discussion.
And this board could make that finding and other findings, and then if this decision were to be appealed, you could argue in the alternative. Is that correct? Yep.
Thank you. Thank you.
Thank you.
All right, so we're going to move on for additional public input and support. Justine. So for the record, introduce yourself and give us your address, please.
I'm Justine Fogarty, 835 South Water Street, Silverton, Oregon. Lifelong citizen of Silverton. And what I could add is this confusing wordage. Shortly after my mother had died, I had gotten hold of somebody at LDC, or LCD, am I saying that?
DLCD.
Okay,
It doesn't matter, we know what you're talking about.
And that person took some time and went back and looked on it and explained it that way, that the 10-year limit would not start until that property was no longer in the name of my sister and me. In other words, when both of us had sold it or passed it on or whatever. And so that was really what our family had been living with, that kind of knowledge. The other thing I just have to say is that I was with my father, who was an immigrant from Canada, a citizen of the United States, and fell in love with the Northwest because of our trees. And when he saw that property, I remember his excitement and love of the land, the wildlife, the trees, has passed on to every member of his family. And that's how we see that property, is something to behold and love. We do.
Commissioner?
I have a question. Justine, thank you for being here. And
Thank you.
Thank you for your family and all those things that it means a lot. You went in, did you go into the office? Did you call them?
I called.
You didn't get any documentation about that conversation?
No, I didn't, unfortunately.
Yeah, okay.
And I don't have the name. That was a while ago.
Okay.
Thank you.
Thank you. Thank you.
Thank you.
And then last for support is Chuck Sheketoff. I'm sure I got. Did I get it right? All right. I get a star for the day. Thank you.
You did better than a lot of the people who announce my name before high school wrestling matches. So.
Oh well. So please introduce yourself and your address, please.
Sure. My name is Chuck Shakatoff. I live at 14388 Evans Valley Road, Silverton, the adjoining property, and I am honored to live in the iconic home that Dr. and Mrs. Dodds built. It was written up in the Statesman Journal in 1957 after it was built. It was designed by an architect here in Salem who had previously designed his office, which is now Silverton Family Dentistry Building, if you want to sort of see the mid-century modern home. It's a mid-century modern home that we updated a little bit, redesigned, but kept basic footprint.
Great, thank you.
So I've submitted comments to the administrative hearing and then comments to you in writing. I'll just summarize those, and I want to bring up one other issue. I really appreciate Commissioner Willis's comments about focusing on this stuff and forgetting about the issue of owner. And I think the problem is the hearing officer decision addresses that, and I think you need to understand the owner issues. But so first, I think you gave the county gave tacit approval by approving the driveway, by and making them put in a culvert, by approving the electrical, and by approving a septic system which takes up more farmland than a septic system would for just a pole barn. The septic system was for a pole barn and a 3-bedroom house.
I think you may have turned off the microphone accidentally, so can you push the button? Thank you.
Sorry.
There's this
So
bullet.
a 3-bed, the septic system you approved as a county took up more farmland than it would otherwise if you couldn't build a house there. Second, I think you have an obligation to measure the issue of ownership consistent with trust law. I don't think you can read it inconsistently because it makes no sense. I mean, under the hearing officer's interpretation, the bank was the owner. The bank couldn't build a house and house its CEO there, give the CEO. You know, people, and if it wasn't a bank as the trustee, think of it as, let's say, an individual. Let's say the Dodds had wanted to use a young, smart, fiscally conservative businessman like Commissioner Concanon as their trustee, because to help his wife, right?
Businessman, I don't know about the description of smart.
You're definitely young and smart.
All right.
It was a hypothetical. So, you know, he couldn't, as trustee, build a house and live there and say to Justine and her sister, you can't use it. I'm building a house. I'm the owner, and I have the right under. And if they had not passed it off, that living trust was still they were still holding it under the living trust today. That became irrevocable, but was a living trust. And he was the trustee, or West Coast Bank. They could not today build a house on it, right? And so that's the thing. Now I sort of wondered why when I read the definition of owner and the bit about a living trust becoming irrevocable, it was a non sequitur. It just didn't make sense with trust and estate law, which I happened to learn because of my parents passing away, right, where I was in those positions. And so I actually it's a non sequitur, and so I actually did a little legislative history research, and legislative counsel reported back to me that they did some as well, and that this was put together sort of in a rush to get it to the ballot by legislative counsel. It was a legislative referral, Measure 49. And it appears that you had a lot of very smart land use lawyers, as you heard from one today, writing this, but they didn't have an estate lawyer look at the estate terms to see if they're used properly. And this bill, the amendment that became this section with the definition of owner is stamped by legislative counsel, and Commissioner Cameron probably remembers seeing this very rarely, if at all, was stamped reviewed for form and style only. There was, which legislative counsel says we rarely do, where we let a committee take a bill, a draft that was written by a lobbyist or a legislative office or someone, and we only review it for form and style, not for whether it's using the right terms. Had this been reviewed, had the amendment been reviewed correctly, the legislative counsel's land use lawyer would have written it up, and it would have passed to the estate lawyers in legislative counsel. Are they using the terms right? And they would have looked at this third thing and said, that doesn't make any sense. The bank doesn't get the right to build a house. They're not the owner, And so it's just poorly worded, that doesn't make sense, and I think you have an obligation to make a decision where things make sense. And I think, you've been shown a path forward, that they're just not the owner. It's just doesn't, it's the finding by your hearing officer that West Coast Bank was an owner and conveyed something, there was no conveyance, there was no consideration. They didn't have the power of an owner. They couldn't have built their own home there. And so I just think that this should be approved. I really am hoping that Josh and his wife Carrie can build a house next to us and become our real neighbors, not just by property ownership, because they're really great people. So,
Thank you.
thank you.
Thanks for being here today, participating in the process. Did you have any questions?
I have a question for Mr. Swan, actually. Thank you. Mr. Sorm, in your opinion, who's the claimant?
The original claimant, Mary Dodds, when Mary passes away, then there's really only one other option, and that is Gretchen and Justine. They were the
The
claimants.
hearings officer mentioned the trust as the claimant, but in your opinion, you would say that's an incorrect statement of the facts, that the claimant was actually Mary. Is that correct?
That's correct.
You would disagree
Yeah,
with
so it's still in Chapter 197, the definition of claimant. The claimant is the person who files the claim.
Great.
That is the statutory definition. So West Coast Trust was not the one that filed the claim. Mary Dodds filed the claim. She was the claimant.
She was the claimant.
While
Thank
she
you.
was alive, yes.
Thank you.
Thank you.
Jane, did you want to?
No, I think Scott was saying he has some things he'd like to just kind of comment on for the board.
Okay, can we get through the testimony, opposition,
Yes.
and then get there? Perfect. So we have one individual signed up in opposition. It's Roger Kay with Friends of Marion County. If you'd please come forward. Hi. Nice to see you.
Good afternoon.
It's still morning.
If I can remove this. Oh, sure.
Sure, he can go ahead and have a seat, and he'll take it down. No, we're gonna sit.
Good morning, Commissioners. Is it on? For the record, my name is Roger Kay, current president of Friends of Marion County. I'm just going to read this briefly because this way I'll be sure I don't miss anything and I cover everything I want to. It's usually my practice.
Okay.
Friends of Marion County is an independent 501c3 farmland protection organization founded in 1998. Our mission is to protect farm and forest land, parks, and open space in Marion County. We oppose and request denial of the administrative review to grant a Measure 37 claim on a 13.53 acre property consisting of 2 tax lots in an EFU zone located in the 14,300 block of Evans Valley Road, Northeast Silverton. Friends of Marion County submitted letters December 30th, 2021, March 10th, 2022, and appeared at the May 13th, 2022 public hearing. We're following up today with a detailed analysis in our letter today on why the property development history requires a decision of denial, and that letter should be in your packet. The Department of Land Conservation and Development submitted comments on January 3rd, 2022, which argued that the application should be denied. The Marion County Planning Administrator came to the same conclusion. On May 13th, Marion County Hearings Officer came to the same conclusion. Our legal arguments show that the home site approval should be denied, and we show that the development history arrives at the same conclusion. The application was filed with the Planning Division on December 17, 2021, approximately 6 months after the 10-year deadline for the home site had expired. The applicant began permitting and construction on the property, including septic service, driveway access, utility service, and an agricultural exempt building on April 3rd, 2019, and which continued to June 22nd, 2020. Agricultural exempt buildings are permitted uses on EFU lands and are not subject to the Measure 3749 statute. The septic work, the driveway access, the plumbing, and the utility permits were designed to service both the agricultural exempt and the residential building. The specific permits and inspection reports are attached in our letter in the file. There were no restrictions to filing permit applications or permit inspections due to COVID-19. The Planning Division was fully operational through email, fax, phone, and Zoom communications, which did not prevent the applicant from getting their application submitted, properly inspected, or permits approved. The Planning Division opened to in-person service sometime in May or June of 2020. The applicant discovered that when filing an application for a residential permit, the 10-year time period has expired. Under establishing dwellings under the Measure 37 statute, I've included the paragraph from that statute. I'm not going to read it, but the important portion here is that the plain language of the statute states that the subject owner must create the lots or parcels and establish the dwellings, quotes, within 10 years of the conveyance. And Merriam-Webster defines establish as to institute permanently or enactment or agreement. Marion County issues a certificate of residential occupancy to determine if the dwelling meets the definition of, quotes, established dwellings under the statute. The certificate is issued only if all of the permits, inspections, and health and safety requirements have been met. If the certificate of residential occupancy had preceded the 10-year deadline of the conveyance, then Marion County could have approved the application for the dwelling. However, the applicant failed this criteria, and the application was denied by the Planning Division and the hearings officer. The beneficiaries of this trust should have realized that the 10-year deadline for development required them to develop the home site. They did not do so in a time permitted and therefore became ineligible to take advantage of the waiver. Therefore, we oppose and request denial. And in my letter, I attached a copy of, if I can find it, a copy of a certificate of residential development. It's called Residential Certificate of Occupancy, and it's in the file, and it said so in the top. This structure has been inspected and approved according to the applicable codes, regulations, and laws that were in effect at the time the permit was issued. All filings have been completed, and this dwelling is approved for occupancy. And this application has not received a certificate of residential occupancy. That's all I have. Thank you.
Thank you. Do you have any questions for Roger? Commissioner?
Oh, good.
Okay, thanks, Roger. Okay, I understand Mr. Norris might have some input.
Yes, once again, this is Scott Norris from the Office of Legal Counsel. The core of applicant's claim is that the beneficiary's interest in a revocable trust vests fee title in the beneficiaries upon the death of the settlor, the person who creates the trust. I don't believe that that is correct.
Is that necessary, Scott? The operative language is acquires the property. So fee title is a specific type of ownership of property, but it's not the only type.
Well, referencing subsection 10 of Measure 49 says that, well, edit as I go here, an authorization to use the property passes to the person that acquires the property by devise or by operation of law. And as I had referenced earlier, there's kind of two operative terms there. There's the property, what is the property that passes, And then secondly, in this context, operation of law. What does that mean in this context?
And what does it mean to acquire, right? So the word acquire matters, the word property matters, and the word operation of law matters. Fee title is one type of property ownership, but it's not the only way to interpret that, right?
I would agree with that.
Okay.
And I think that that's explained in the Uniform Trust Code. Oregon has adopted the Uniform Trust Code. It's codified in ORS Chapter 130. First of all, ORS 131.730 says the interests of a beneficiary of a revocable or irrevocable trust vest when the trust becomes irrevocable and not later. So it's the interest of the beneficiary that vests. It's not fee title, it's not outright ownership as such. It is the interest of a beneficiary that vests.
But the question is whether the interest of the beneficiary is a real property interest. That's the question. Because if the answer is yes, then I could read that and say that person acquired the property because they got a real property interest at that time.
It is an interest in the property, but it is not the property. It is not the entire bundle of sticks. It's more, I would argue that it is more akin to an easement, where you have an easement is an interest in land. It is a right for use of the property, but it is not an interest in the fee. The owner of the land is still the holder of the fee. The holder of the easement has the right to use and enjoy the property in accordance with their easement. And I think the same concept applies here in the context of a beneficiary and the beneficiary's interest in the trust property according to the terms of the trust.
But I think the question, and this is I think what the applicant's arguing, is that in the case of the moment when a trust becomes irrevocable, the trustee can make certain decisions with regards to the property, but cannot make other decisions with regards to the property. And I think in a similar way, the beneficiary has interests in the property that vest when the trust becomes irrevocable as well, right? So and this is what I didn't want to get into because I don't think it's necessary for settling this, and I think it potentially could create more confusion. But I think the focus on fee title is not necessary to determine that the person acquired the property at the time that the trust became irrevocable, right? Because if you say the only thing that acquire the property can mean is fee title, well, then you have a situation at the time that the trust became irrevocable that nobody had fee title. Not in the sense that we understand it, that I can prohibit anybody from coming on my land, I can use my land however I want, I can make a profit on my land. Neither the trustee nor the beneficiary had unlimited rights the way that a fee owner does in that sense.
Correct, in that the trustee is acting in furtherance of carrying out the terms of the trust, subject to the trustee's statutory fiduciary duties. That is described in ORS 137.20, which describes the general powers of a trustee. Then ORS 137.25 goes into detail about additional fiduciary duties. In general, under 137.20, the trustee can exercise, I'll quote it, all powers over the trust property that an unmarried, financially capable owner has over individually owned property, and any other powers appropriate to achieve the proper investment, management, and distribution of the trust property. Leave out additional here, and then it concludes, the exercise of a power is subject to the fiduciary duties prescribed in ORS 130, 650 to 730. So the trustee has broad powers over management of trust property, consistent with the terms of the trust and consistent with the trustee's fiduciary duties. So it's, and if it were that the beneficiaries had ownership over the property upon the death of the settlor, then at best, the deed from the trustee to the beneficiaries was a meaningless act. And at worst, a meaningless act in that the beneficiaries already owned the property in question. And at worst, was fraudulent because the trustee was purporting to convey an interest in land that it no longer held.
This is why I don't think we have to get into the ownership question, because the term ownership is a statutorily defined term in a separate section of Measure 49, right? So when you're interpreting that section of Measure 49, you have to go to the definitions and figure out what does that word mean as defined by the statute. But when you're interpreting Section 10, all you have to find out is, did the person acquire the property by devise or operation of law? And so you don't actually have to interpret the term ownership to determine that. What you have to interpret is the term acquires, the property, and operation of law. And so I don't think we have to come to the ultimate conclusion about what does ownership mean. The only question we have to answer is, did the beneficiaries in this case acquire the property by operation of law? And I think in this case, the reason why I think we can say they acquired the property by operation of law is because the trustee could not have transferred that property by himself to whoever he wanted at the time of the settler's death. That would be a fraudulent transfer. And the reason he couldn't is because of the Uniform Trust Code. Because at the time of the settler's death, that law went into operation, transferring a property interest to the people who inherited under that trust, right? The beneficiaries of that trust. So that's why I think the ownership question is actually potentially could create a whole bunch of problems for us. I think all we have to find is that the claimant was an individual, Marion, that she died after 2007, December 2007, and that her beneficiaries acquired the property by operation of law. And if we find those three things, then I think that gets us where we want to go. And the reason I think that is because you could get into this question about ownership, and if you start interpreting and defining those terms, that could throw all sorts of questions about people who inherit property via will or somebody who dies intestate, right? Currently, everybody agrees that if the applicants here had inherited this due to a will, then we wouldn't be in this situation, right? And I think once we start defining what ownership looks like in that context outside of what the statute says, all of a sudden you can have bigger questions. Whereas if we just focus on, did they acquire the property by operation of law, all we have to say is, did they acquire the property? We don't have to interpret what does ownership mean. Doesn't matter what property right they acquired. We just have to say that they acquired the property. And I think you can read trust law in accordance with Measure 49 in a way that those things are consistent.
The final thing I wanted to point out has to do with operation of law, the term operation of law. It's important to remember that a settlor, there's nothing in law that compels a settlor to distribute the residue of a trust to the beneficiaries. The settlor could create the trust to, for example, distribute the residue to a charity or to another trust or in some other way. So there's nothing in law that necessarily compels a settlor to distribute the residue of a trust to beneficiaries it's the terms of the trust agreement itself that compel that.
But at the time of the settlor's death, those terms can't be changed anymore, correct? Once it becomes irrevocable.
That's correct. But once again, that's not being compelled by the law, or the distribution as such is not compelled by the law, it's compelled by the terms of the trust.
But the law is operating, right? Because before the person dies, those terms can be changed. Once the person dies, specifically with the residue, right? The law is what says what happens in the case of ambiguity or if nothing is said, right?
The law does, but ultimately it's carrying out the terms of the trust that is going to control, subject to fiduciary duties and the terms of the trust.
Right, but I guess the way I'm thinking about it in this instance, the trustee couldn't, for instance, change their mind. They couldn't say, oh, the trust says X, but I'm going to do something else with the property, right? And the reason they couldn't is because the law controls. They are not the agent in that moment.
Right. It's going to be upon the trust becoming irrevocable, the trust, well, and I suppose I would say even before the trust becomes irrevocable, the trustee is obliged to carry out the terms of the trust and act in accordance with their fiduciary duties. That's true from the get-go of the trust, and not just when the trust becomes irrevocable. But once the trust does become irrevocable, then the trustee is carrying out the terms of the trust subject to their fiduciary duties. And if they violate the terms of the trust or their fiduciary duties, the Uniform Trust Code spells out remedies which can include avoidance of a fraudulent transfer, damages against the trustee, recovery of funds that had been received for transfer and violation of the trust, any number of remedies that the court can apply in a given situation.
Yeah.
Scott, the final question is, the applicant brought up this issue of having done a lot of work to get the house built, basically, but they hadn't gotten all the way. How would our finding in that regard matter to the applicant's ability to build this house, if at all?
That would be in the nature of a vested right. And in the context of a Measure 49 was sort of in the alternative, where you could pursue your vested right, if you had a vested right at the time, and complete that Measure 37 waiver in accordance with your vested right, or you could apply to Measure 49 for relief in accordance with Measure 49. It's a timing thing. So this would be actions which have been taken since the acquisition of a Measure 49 order in furtherance of that Measure 49 order. I don't know how vested rights would apply in that kind of situation. I don't believe that has really been explored before.
Okay.
One thing I might be worth adding at this point, and I don't know how much this is going to may apply in this situation. Measure 49 may not be the applicant's only avenue for obtaining a permit for the construction of the residence. It may be eligible under our code for a a type of dwelling permissible. If I remember right, this is in the AR zone. So it may be eligible for a dwelling otherwise in the AR zone.
This is EFU.
It's
Oh, it is an
EFU. It
EFU.
formerly was an AR in the 70s.
It may still be potentially eligible for a dwelling, depending on the circumstances. If I remember right, these were non-high value soils, so there may be other avenues available.
Okay, thank you. Please come back for closing. Yep, well, and you have closing comments.
Just a quick 30 minutes.
Madam Chair, can we recess for 5 minutes?
Yeah, we might need 5 minutes,
No,
if that's the case.
I will keep it under 5 minutes.
Okay.
Trying to make 4 points just here in closing. I appreciate a lot of hard work from staff, from the hearings officer, for everybody who's participated in this matter. And this goes to kind of the first point. One of the things that jumped out at me when I read the hearings officer's decision is she felt her hands were tied. She said, unfortunately, there's no ambiguity. I have to do this. And I think what this exercise has established is, particularly when you start getting into questions of ownership and things like that, we're in the area where reasonable people can differ. So there's ambiguity in the statute, and we're well within our rights to go ahead and use the tools available to us, statutory construction. We got to apply Measure 49, the Trust Act. We got to make it all work. We got to do it in a manner that's consistent with the purpose and intent of Measure 49. And we know what's the most clear thing, as Commissioner Willis has spoken to, is that Measure 49 claims both the right to prosecute the claim and the right to use the Measure 49 orders expressly by the text, not affected by the death, and they go to the people who inherit them by devise or by operation of law. Beneficiaries do have a vested property interest. We don't need to get into whether or not they're fee title. That's not even the only thing. There's fee title absolute to go back all the way back to property class, recognizing a whole host of different interests. But it seems that there is an agreement that the beneficiaries do have an ownership interest, and they did, by operation of law, inherit that. And even though we have to look to the Trust Act to figure out who the names are, it is by operation of law. You can go ahead and get a court order as a beneficiary to the trustee. Say, hey, you have to go ahead and follow this Trust Act, and you can get a court order to effectuate that. It's not just a private instrument. Councilor Norris spoke a little bit about the vesting and the options. Most of that, it's not really applicable as far as vesting it was commonly discussed under Measure 37. That's not what we're doing here. It's just a question, did we satisfy the condition? Did we establish a dwelling prior to the expiration date? Even if you were to look to the expiration date as suggested by the state and the hearings officer. We think that Mr. Fogarty did do enough, that it's not a bright line test to get the building permit, that he did establish the dwelling. So those were the major points that I wanted to just hit on rebuttal, closing arguments. If there's any questions, points of clarification, I can happy to do that. But I do appreciate you all not waiting to the very end, being an active participator in this hearing. It really does help us as people who are testifying to be able to speak to what you need to know. So thank you.
You're welcome. I don't know how to do it any other way. Okay.
I just have a question for Aaron. Hey, Aaron. Aaron, would you prefer that we make a decision today or remand it to the hearings officer? Alan, I'm sorry.
Yes, thank you. Yeah, we would ask that the board close the hearing, close the record. This is a question not really relying on new evidence, and that we think that everything is in front of the board. So if the board is comfortable going ahead and deliberating, we think everything that the board needs is in front of them, and are not asking for continuance or for the record to be left open in any way.
Thank you.
Thank you.
Go. You have
Go
so
for
many
it.
notes.
Do you want me to just make the
Yeah,
motion? Or do you want me
Yes,
to?
no.
Okay.
I mean,
Make a motion and we can talk about it.
yeah.
Okay. So, Madam Chair, I would move that we close this public hearing and approve the request with the following findings. That we find that Mary was the claimant, and she is an individual. That we find that she died after December 6, 2007. And that we find that Gretchen and Justine acquired the property by operation of law. And that we find that Joshua established dwelling prior to the year 2020.
Good? I'll second the motion.
Great.
You have a motion and a second. You want further discussion?
Yeah, sorry. I was waiting for you to start talking at the. So I have a motion and a second. Is there any further discussion? Okay, hearing none. All those in favor, please say aye.
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 Aye, the motion passes. Thank you, everybody, for your time today and the length of this hearing. I'd like to have a chat with you right after this, Lindsay. So, good luck. Now I will return back to our regular agenda, and I would love it if Mr. Cameron would read the calendar, please.
Absolutely, Madam Chair, thank you. I'm gonna go like quick.
Do it.
Yeah, because I'm gonna need to
Yep.
go. All right, yeah, we're here. Today is well, it's already starting on, we have nothing the rest of the week. Am I looking at the right calendar?
Yeah.
It doesn't start till July 7th?
That's right.
Okay, wow. Okay, that's right.
Yes.
But nothing later today or, well, I guess those
Well,
was
there's
last
no
week.
quorum things.
Right,
today
right,
or
right. Okay,
tomorrow.
so Wednesday,
If you would, please take conversation out to the hallway, because we need to finish our meeting.
all right, let me check some dates here because it says Wednesday the 6th and Thursday the 6th. So let me get this right on the calendar. Okay, it is Wednesday the 6th at 1:30 in the afternoon, BOCCA.
That's, so, yeah, technically, we're here right now, which would typically be on there.
No, we don't need to announce that, everybody knows we're here. So today is, the first meeting that's on here is Wednesday the 6th at 1:30, BOCCAO meeting. We may not do that.
Correct, we'll
But
change that.
it's on here right now. On Thursday the 7th
Yes.
at 9 a.m., SOAR graduation at Chemeketa Community College, 4000 Lancaster Drive Northeast, Building 60. On Thursday, this is messed up.
Yeah.
On Thursday, the 7th, at 8:30. No, that should be Friday, the 8th.
That's right.
Friday, the 8th, Marion County Fair Greeters, location Oregon State Fair and Exposition at 23300 17th Street Northeast. Friday, the 8th at 11:30 a.m., 2021 Volunteer Awards presentation at the Oregon State Fair Exposition Center. And Friday, the 8th at 2 p.m., Forest Trust Land Advisory Committee, virtual. Friday, the 8th at 4 p.m., opening day, no-host barbecue with Oregon State Fair and Exposition Center. And Monday, let me check these dates, make sure, because we were off there. Monday is the 11th. Monday, the 11th at 3 p.m., the Association of Oregon Counties Board of Directors meeting, virtual. Tuesday, the 12th, 7:30 a.m., Cities in Marion County's location at Newfeld's Restaurant at 190 Main Street, Almsville. And Tuesday, the 12th, at 9:30, management update here in the Commissioners Boardroom on the 5th floor. Tuesday, the 12th, noon, IT appreciation luncheon. Wow, human resource training room on the 4th floor. And on Tuesday, the 12th at 4 p.m., Marion County Public Safety Coordinating Council in the Commissioners Boardroom here on the 5th floor. And on Wednesday, the 13th, we're back here at our board session. And on Wednesday, the 13th at 12 o'clock, the BOCCAO meeting.
Thank you. Jane?
On the fifth floor.
I was just gonna comment that there is a calendar for this coming week online. I don't know if you guys want to read it or if you just want to tell the public. You do have some activities between the 29th and July 6th that are listed on this online calendar as well.
Thank you. So as always, our calendar is online. We apologize for the error for the printed one, and hopefully it's only messed up for us. We will make sure staff corrects that, and if you have curiosity as to where we'll be over the next week, go to Marion County's website. With that, the meeting is adjourned. Thank you.